I don't know about you all, but where I'm at, gun stores are getting cleaned out. It all started with a single sentence buried in a quiet court filing, a routine DOJ brief. It triggered a nationwide rush on suppressors, threaded barrels, integrally suppressed guns, and subsonic ammo. Makes you want to ask, what the hell just happened? Today, we'll break down the legal shift that sent shockwaves through the firearms world, how the DOJ flip-flopped on a core constitutional issue, and why suppressors are suddenly being treated less like contraband and more like seatbelts. We'll also look at the ripple effects, lawsuits across multiple states, supply chains adapting on the fly, and what's in it for you and me. This isn't just a court win, it's a cultural turning point. While the ATF still clings to the old rules, buyers, businesses, and even lawmakers are already sprinting in a new direction. This shift could collapse the entire NFA framework. Heck, it could be the beginning of something even bigger. Stick around, you won't want to miss it. So not too long ago, the DOJ quietly filed a supplemental brief in Vanderstock v. Garland, and buried near the middle of the document sat a sentence that flipped 90 years of federal doctrine on its head. A suppressor is an arm protected by the Second Amendment. The admission felt surreal. For decades, the same institution defended tax stamps, fingerprints, and year-long backlogs as if the world would end without them. Yet there it was in plain language, and anyone reading could almost hear the hinges creak on a very old door that had been welded shut since 1934. As soon as the brief hit Pacer, my phone lit up. Shop owners, range buddies, first-time buyers, they all wanted the same answer. Does this mean the fight is finally turning our way? It turned because Bruen rewired the way courts weigh gun laws. After that Supreme Court ruling, interest balancing went in the trash, and every restriction now has to trace back to founding-era practice. The problem for the government is obvious. Nobody in 1791 filed a form or paid a levy before suppressing a musket. Suppressors only became federally regulated during the Great Depression, not during the founding era. They first appeared around 1902, invented by Hiram Percy Maxim, and were marketed in sporting catalogs as hunting and target shooting accessories, not criminal tools. By 1930, Maxim himself had stopped producing suppressors after only a few thousand units, largely because public perception had shifted. People believed they enabled poaching and gang-style violence. In 1934, Congress passed the National Firearms Act, imposing a prohibitive $200 tax and registration requirement, a sum equivalent to over $4,700 today, to discourage ownership. Silencers were lumped in alongside machine guns and short-barreled rifles, despite no legislative evidence that they were actually used by criminals in significant numbers. Heck, court hearings from that era show that not a single member of Congress cited concrete data on silencer misuse. Many lawmakers openly expressed suspicions without evidence, some announcing that anyone who's carrying a silencer must be up to no good. So it was far from being about public safety. It pandered to social elites and scared livestock owners who feared that unregulated suppressors would let poachers hunt quietly on their land. They simply used the tax to price regular folks out of ownership. That's the historical gap. So, once lawyers started hammering that gap, the DOJ saw it had two choices: cling to an argument that couldn't survive appellate scrutiny or concede the point and try to salvage as much control as possible. They picked the latter, probably hoping the damage would stay confined to one case. Reality had other plans. Within hours of the filing, social media flooded with screenshots. An idea that seemed radical 5 years ago, suppressors are normal shooting gear, suddenly carried federal endorsement. That single shift lit the fuse on the consumer side. Walk into any reputable FFL 2 days later, and you could see empty pegs where suppressor boxes used to sit. Silencer Shop streamed an emergency Q&A and revealed a 400% jump in orders over 48 hours. Capital Armory, Dead Air's web store, even the smaller boutique makers could not keep inventory data current. One technician joked that the only cans left on the shelf were demo units with the Cerakote scrubbed off from too many range days. If you tried filing a Form 4 through the ATF's eForms portal that week, you watched the status wheel spin like it was stuck in mud. The servers simply weren't built for that surge. The spike isn't stopping at silencers. Threaded barrels, piston kits, subsonic projectile lines, and integrally suppressed guns are riding the same wave. Palmetto State's run of B&T APC-9 SDs sold out the morning they restocked. Ruger's silent SR packages vanished before some distributors finished uploading product photos. Ammo vendors reported that every flavor of subsonic 300 blackout and 147 grain 9mm left their warehouses in pallet lots. This wasn't the usual collector binge either. I called 5 shops in 3 states. Each one told me the bulk of buyers were not NFA regulars. They were parents who wanted to introduce kids to shooting without earplugs the size of wine corks, farmers looking to keep coyotes off the property at dawn without waking the county, and older sportsmen whose tinnitus already sounds like a tea kettle. When mainstream America starts embracing gear that politicians have painted as sinister for decades, the culture is moving. That cultural swing owes a lot to how people now frame suppressors. No one argues a seatbelt is a luxury, or that smoke detectors are gadgets for gearheads only. The more folks learn that quality cans can reduce recoil, tame flash, and spare long-term hearing, the less they buy into Hollywood tropes about quiet killers. Any hunter who's fired a suppressed bolt gun at dawn knows it still cracks, just not at jet engine levels. Rifles that once rattled windows now sound like someone shutting a screen door. When neighbors appreciate the difference, neighborhood objections fade, and local acceptance snowballs. That feeds back into demand, which lowers prices through volume, which drives even wider adoption. I've seen this feedback loop in real time, and it's forcing lawmakers to reassess how winnable their battles really are. Legislators in states that banned suppressors sensed the shift almost overnight. Within a week of the DOJ brief, gun rights attorneys in New Jersey filed Padua versus Platkin, quoting the federal concession line by line. Friends in Massachusetts told me drafts are circulating to launch a mirror suit there, and Illinois and New York are not far behind. The argument is simple. If the federal government says cans are protected, a blanket state prohibition cannot survive Bruen's text and history test. Courts now have to pick between defending a state rule that lacks 18th century precedent or aligning with new federal guidance. Either route risks a circuit split big enough to bring the Supreme Court back into the fray, and nobody wants to be the judge who ignored Bruen and got reversed on national television. Those legal tremors coincide with another fault line: unfinished receivers and so-called ghost gun kits. Vanderstock challenged the ATF's attempt to classify 80% lowers as firearms. The Fifth Circuit, then the Supreme Court, ruled that a non-functional hunk of polymer is not a gun, even if you can convert it later. That decision, delivered mere weeks after the suppressor concession, tightens the vice on administrative agencies. If bureaucrats cannot redefine a plastic shell as a rifle, and they cannot treat a tube with baffles as contraband, their regulatory reach shrinks by the day. The trend is clear. Judges are no longer comfortable handing agencies a blank check to police accessories in the name of public safety. I'm curious how you all see this. Do you think bans in anti-gun states will survive once judges read the federal brief out loud in a courtroom? Will lawmakers double down or quietly pivot before the next election? My gut says we'll witness a patchwork of emergency bills. Some legislators will attempt to impose alternative hurdles, like mandatory cereals at the factory, or licensing fees disguised as impact assessments. Yet every new hoop must still cross Bruen's historical bridge, and that bridge is getting more and more difficult to cross. Inside the ATF, there is real unease. Agents continue processing Form 4s because the statute hasn't vanished, but they can read the court dockets as well as anyone. Rumors leak of brainstorming sessions where attorneys float backup plans, shifting suppressor oversight to the Food and Drug Administration on a hearing protection device theory, or enlisting the Commerce Clause to demand manufacturer-level engravings linked to interstate databases. Every workaround looks fragile under Bruen. One federal litigator told me off record that trying to pass suppressor serial mandates through Congress now would be political self-harm. That's an extraordinary admission from someone who argued for those serials just a year ago. Meanwhile, the commercial landscape is already adjusting. A pair of shops in Idaho ordered new Haas mills specifically to ramp up can production. A family-run range outside Savannah posted a sign reading, "Quiet Tuesday." and offered discounted lane fees for suppressed shooters. Parents showed up with Youth 22s and left asking where to buy rimfire cans. Manufacturers are rolling out lighter alloys, quick-detach mounts with zero-shift guarantees, and modular baffle stacks that handle everything from 308 to 65 cm with a simple spacer swap. Innovation grows when red tape fades, and the consumer gets better tools at lower cost. You can almost see the future where suppressors sit on the same shelf as cleaning kits. Grab one off the peg, walk to the counter, fill out a standard 4473, and head to the firing line. None of this means the fight is done. The NFA still governs SBRs, SBSs, AOWs, etc. Agencies are resourceful when defending budgets and authority. A judge in one circuit may uphold a state ban even while another strikes it. Those inconsistencies will sow confusion, and confusion chills exercise of rights. Yet I keep returning to the same conclusion. Every time a court applies Bruen faithfully, the constitutional side gains ground. The DOJ concession revealed that even institutional defenders know their old justifications no longer pass muster. They can try new angles, but the slope is steeper now. That raises practical questions. If you live in Kansas or Texas, do you wait for stamp fees to drop before buying? Or do you jump in and start the clock? I know some who worry that filing today maps their name onto a registry that may become illegal tomorrow. Others argue that once the wave crests, demand will dwarf supply and lead times will stretch regardless of the tax. I see merit in both views. Personally, I filed for a rimfire can the week the brief came out because I'd rather lock my place in line than be stuck behind another surge. If Congress kills the tax 6 months from now, I lost 2 Benjamins. A gamble I accept for the chance to have the silencer in hand sooner. But I want to hear your strategy. Are you filing? Holding off? Betting on legislative relief? Drop your thoughts. The community learns faster when we pool experiences. Dealers are watching too. A Boise gun store owner I know claimed that he sold more Ruger American Ranch rifles in .300 Blackout with threaded barrels that week than in the previous half year. He's now considering a layaway program tied to suppressor orders because customers love the idea of paying both items off during the wait. Creative retail tactics can buffer the remaining bureaucratic friction. If shop owners adjust business models, manufacturers see the demand forecast and spin up production, and the ATF becomes the sole choke point. Public impatience will only intensify the call for reform. In parallel, economists who track the outdoor industry are revising forecasts upward. When Form 4 approvals break 100,000 per quarter, entire supply chains shift. Titanium tube suppliers, baffle machining contractors, Cerakote vendors, everyone down the line adds capacity. Firearms enthusiasts also benefit from this, in that there will be more competition in the suppressor space, and more competition means better quality and lower prices for the consumer, regardless of the industry. CNC shops that once specialized in AR parts are now quoting silencer runs. Coating companies are offering thermal-resistant finishes. Even boutique makers, who used to hand-build 10 cans a month in a garage, are partnering with logistics firms to go national. As barriers drop and volume rises, innovation speeds up. We're already seeing quieter rimfire designs, modular baffle stacks, and cans that weigh less than a loaded magazine. Average prices that used to be between $375 and $1,000 are creeping below $150 to $250. And with every price drop, more shooters jump in, fueling the cycle all over again. It's not just a market surge, it's a reinvention. And that wraps it up for this one. Are you jumping in now or waiting to see how this plays out? Drop your take in the comments. Your experience might help someone still on the fence. Hit like, share this with your crew, subscribe if you haven't already, and tap that bell icon. Things are only heating up.